Breaking today. If you filed Form I-589 and you're still waiting for your interview, your case could now be sent straight to immigration court, and you won't even get a chance to speak with a USCIS officer first. If you filed Form E-589 with USCIS and you still do not have an initial asylum interview date, your next notice could move your case to immigration court before you ever speak with a USCIS asylum officer. An interim final rule that took effect on July 28, 2026, gives USCIS this option in certain affirmative asylum cases. This does not stop every asylum interview. It does not reject every pending case. It also does not mean automatic removal. But for some applicants who do not have another lawful reason to stay in the United States, the written application and the evidence already in the file may now determine whether USCIS schedules an interview or refers the case to court. In this video, you will learn what changed, who may be affected, who is probably not affected, what happens after a referral, and what you should review before USCIS acts. Important as of July 28, 2026. This rule is in effect now. The Department of Homeland Security and USCIS issued it as an interim final rule. That means the rule can begin working while the government accepts public comments. The comment period is open for 60 days after publication. Later, agency guidance, legal challenges, or a court order could change how the rule operates, but applicants should follow the rule that is active today unless an official notice says something different. First, let us be clear about what this rule covers. Affirmative asylum usually means a person inside the United States files Form Y-589 with USCIS before an immigration judge is deciding the claim. Defensive asylum is requested after removal proceedings begin. This rule changes one part of the affirmative asylum process at USCIS. It does not control regular visa interviews at a United States embassy or consulate. Before this change, USCIS generally scheduled an asylum interview before deciding what to do with an affirmative case. An officer could ask questions and let the applicant explain unclear dates or missing facts. USCIS could then grant asylum, deny the case in some situations, or refer it to immigration court. Now, the order can be different. A USCIS asylum officer may first review Form Y-589, the written statement, supporting documents, government records, background checks, and other facts already available to the agency. In certain cases, the officer may decide that an interview is not needed before referral. USCIS may then send the application to the Executive Office for Immigration Review, known as EOIR. EOIR is the part of the Department of Justice that runs the immigration courts. There is an important limit here. The rule allows referral without an interview. It does not require USCIS to refer every possible case. An officer may still decide that an interview is necessary. USCIS also says it will still interview a person before granting or denying asylum. The agency says it will continue to offer an interview when the applicant maintains a lawful basis to remain in the United States. The words lawful basis to remain can be hard to understand. Valid immigration status may be one example, but parole, temporary protected status, a pending application, or another form of permission can raise more complicated questions. A visa stamp also does not always show how long a person may stay. Do not guess about this point. The answer depends on current records and the person's legal situation. A referral is serious, but it is not a final removal order. It means the asylum claim may move from USCIS into removal proceedings before an immigration judge. The judge can review the asylum claim again. The person may give testimony, present evidence, and explain a legal exception that applies to the case. However, immigration court is a more formal setting. A government lawyer may take part, court deadlines apply, and missing a hearing can cause very serious problems. Now, let us look at who may feel this change first. The rule applies to new affirmative asylum cases and to some cases that were already pending when the rule took effect. Pending applicants who have not yet been scheduled for an initial asylum interview may face review under the new process. If your interview is already scheduled, do not assume it has been canceled. Keep preparing and go to the appointment unless USCIS sends an official notice that changes or cancels it. People whose asylum has already been granted are not losing that approval because of this rule. People already seeking defensive asylum are already in court. The rule also does not target one nationality. The key questions involve the type of case, whether an interview is scheduled, whether the person has a lawful basis to remain, and whether the written record shows a possible legal problem. The first major concern is the one-year asylum filing deadline. In general, a person must file for asylum within 1 year of the last arrival in the United States. There can be exceptions for changed circumstances or extraordinary circumstances. Changed circumstances may include a major event that affects the person's need for protection. Extraordinary circumstances may include a serious event that directly caused the delay in filing. The person normally must also file within a reasonable time after the event or problem. Under the old process, some late filers expected to explain the delay during the asylum interview. That is now a risky plan. If Form I-589 shows that more than 1 year passed after the last arrival, but the written file does not clearly explain a possible exception, USCIS may decide that the case can be referred without an interview. The immigration judge may later review the deadline issue again, but the applicant could enter removal proceedings sooner than expected. Imagine a person named Elena. This is only an example. Elena entered the United States in May 2023 and filed for asylum in August 2025. She says a serious mental health problem stopped her from filing earlier. Her written statement only says that she was ill. It gives no clear dates, no records, and no explanation of how the illness caused the delay. Elena believed she would explain everything during her interview. Under the new rule, USCIS may review the written file first and decide that the case should go to court. This does not mean Elena should invent a stronger story or create new proof. It means she should review the true facts, find real records, and get qualified help before sending a correction or added statement. A late filing does not always end an asylum claim. A real exception may exist, but the explanation and proof may now matter before an interview is ever scheduled. Unaccompanied children have a special rule because the 1 year filing deadline generally does not apply to them. That deadline alone should not support a no-interview referral in such a case. However, another eligibility issue could still affect the application. If you're finding this breakdown useful, hit subscribe right now because immigration rules are shifting fast in 2026 and I'm covering every change that could affect your case the moment it happens. The second major concern is the written application. Form I-589 may now carry even more weight before an applicant speaks to an officer. USCIS may review names, dates, family details, entry records, prior filings, arrests, travel history, group membership, and every answer on the form. It may also compare the application with other government records and background checks. USCIS may send a request for evidence, often called an RFE. An RFE is a notice asking for more proof or a clearer answer. But the new rule does not require USCIS to send an RFE before every referral. Some cases may be referred without an interview and without an RFE. This means applicants should not depend on the government to find every missing fact and give them time to fix it. At the same time, do not send a rushed package only because you heard about this rule. A new statement that conflicts with the first filing can create another serious issue. Review the full case before adding anything. Check names, entry dates, addresses, family details, prior visa forms, border statements, police records, court records, and translations. If something is wrong, do not hide it. Explain the correction truthfully and follow the current filing instructions. The goal is not to make a story sound more dramatic. The goal is to make the true record complete, clear, and consistent. Never use a false letter, altered paper, fake witness statement, or made-up date. False information can damage the asylum case and may create other immigration or legal problems. The third major concern is what happens after referral. USCIS should send a written notice that explains the reason for the referral. The person may also receive a notice to appear, often called an NTA. This is the document that lists the government's claims and starts the path toward removal proceedings. The court case normally begins after the NTA is properly filed with the immigration court. Once the case is in immigration court, the setting changes. A USCIS asylum interview is designed as an agency interview where the officer asks questions about the claim. Immigration court is a legal proceeding before a judge. The Department of Homeland Security may have a lawyer in the case. The applicant may need to answer the charges, meet filing dates, submit proof under court rules, attend early hearings, and later testify at a full hearing. The immigration judge does not simply accept the USCIS referral as the final answer. The judge can review the asylum request again. The judge may consider the person's statement, documents, testimony, country facts, deadline exception, and other forms of protection that may be available. The judge may grant relief, deny relief, or enter a removal order depending on the law and the facts. Appeal rights may also exist, but deadlines can be short. Many viewers will ask about work permits. The rule does not say that referral alone cancels every asylum-based work permit. Work authorization follows separate rules involving whether the asylum case remains pending, the card's end date, renewal rules, and the asylum EAD clock. Some delays caused by an applicant can affect that clock. Anyone with a renewal or clock problem should get case-specific help. The government estimated that 444,724 pending cases could fall within a group that may receive review under this rule, especially cases with a possible one-year filing issue. That is about 31% of the backlog used for the estimate. The government also estimated that about 132,167 future applicants each year may fall within possible referral groups. These are planning estimates. They do not mean all of those cases will be referred or denied. Consider another example. Kareem filed for asylum years ago and expected an interview where he could explain translation mistakes. Instead, he receives a referral notice. Kareem may think his case is over, but the judge can still hear the claim. His best response is to get the full file, identify real errors, save every notice, check the court case, and prepare before each deadline. Our goal is to explain the real risk without adding false fear. The real warning is that some applicants can no longer assume they will receive a USCIS interview before their case goes to court. The written form, the filing date, the evidence, and the explanation of any legal issue may now matter much earlier. The false rumor is that every asylum case has been denied or that every applicant will be removed without a hearing. The rule does not say that. What should you do now if you have a pending affirmative asylum case? First, get a complete copy of everything filed. Include Form I-589, your statement, translations, identity documents, entry records, proof, receipt notices, and later filings. Do not rely only on memory. If a lawyer or preparer filed the case, ask for the full copy. Next, compare your last arrival date with the date USCIS received, Form I-589. Check your passport, I-94, record, travel history, and prior forms. If more than 1 year passed, review whether the file explains a possible exception and why you filed within a reasonable time. Check whether an initial asylum interview is scheduled. If it is, keep preparing and attend unless USCIS sends a written change. Do not skip it because a social media post says interviews have ended. Review whether you may still have another lawful basis to remain. A visa, an I-94 record, parole, temporary protected status, and a pending application do not all mean the same thing. Get qualified advice when the answer is unclear. Check the application for blanks, wrong dates, missing pages, weak translations, and conflicts with other records. Do not send a correction until you understand how it fits with the full case. Every added statement should be truthful and clear. Keep your address current with the correct agency. If the case moves to immigration court, follow the separate EOIR rules. EOIR says a person must report a contact change within 5 working days. Updating one agency may not update the other. Save every notice and envelope. If you receive an NTA, a referral notice, or a hearing notice, read every page. Check the court date, address, and filing instructions. Use official EOIR tools to confirm hearing information. Do not miss a hearing. Do not withdraw the case, file a second form, send a large unrelated packet, start a lawsuit, or make a major travel decision because of one video. Do not copy another person's statement, change dates, or hide an arrest, prior filing, border contact, or immigration problem. Now, let us correct 3 common rumors. The first rumor says USCIS has ended all affirmative asylum interviews. That is false. USCIS may skip the interview before referring certain cases. The agency still says it will interview before granting or denying asylum, and an officer may schedule an interview when more facts or testimony are needed. The second rumor says referral to immigration court means immediate removal. That is false. Referral can place the person in removal proceedings, which is serious, but it is not a final removal order. An immigration judge can review the asylum claim and other protection that may be available. The third rumor says USCIS must send an RFE before it can refer a case. That is also false. USCIS may ask for more proof, but the rule allows some referrals without an interview and without an RFE. This is why the written file now needs careful attention. The balanced message is simple. Do not panic, but do not assume every case will follow the old process. Many applicants may still receive interviews. A referral is not the same as a final removal order. A late filing may have a real exception. An immigration judge may still hear the claim and review the evidence, but early preparation can reduce mistakes that are hard to fix later. This information is current as of July 28, 2026. Immigration rules, agency instructions, and court decisions can change. This video provides general education and is not personal legal advice. Every case has different facts. Anyone with a filing deadline, criminal history, prior removal case, fraud concern, official court notice, or other complex issue should speak with a qualified immigration lawyer or an accredited representative. If this update helped you, like the video and share it with someone who has a pending affirmative asylum case, and if you haven't already, subscribe now for clear, verified immigration news the moment it drops. In the comments, tell us which topic you want explained next, but never post private case details. Stay informed, protect your records, prepare early.